Hedges, who is the director of the Indiana University Intellectual Property Law Clinic. And he's brought along several of his law students to talk to you a little bit about intellectual property law, so please give them a warm welcome.
Thank you, Andrew. Is that coming across okay? All right, great. Thank you, Andrew. So yes, I'm Norm Hedges. I'm a 1995 mechanical engineering grad from Purdue University. I found my way down to the law school in Bloomington after that, and I spent about 20 years in private practice in the law firm environment. And for about the last 3 years almost now, I've been the director of the Intellectual Property Legal Clinic in Bloomington, where we provide free legal services to startups and individuals in need of assistance in the patents, copyrights, and trademarks arenas. As part of my class, I require my students to do public speaking because I've found that after you do a couple of public speaking engagements, you get much better at them and they're not near as nervous about that. So with that, I have 4 of my students here. One of them's out parking their car right now. But what they're going to do is kind of give you an introduction to intellectual property. And if you have any questions, feel free to ask during the presentation. But with that, I'll turn it over to Alyssa.
Thank you. I'm Alyssa. I went to IU, as they mentioned earlier, so sorry to disappoint you about that. I have a biology background, and I'm in my 3rd year down at Maurer. First up, basically what we're going to talk to you about today is the 4 main pieces of intellectual property. Intellectual property protection is going to cover a lot of creative work, so things like inventions, art, recipes even, which is what Ryan will talk about to you later, brands, which China's going to talk to you about. But first I'm going to talk to you about patents, which is going to cover inventions. So patents originate from the Constitution. I actually have the very first patent that was ever issued up there. They look a lot different than that now. So what patents actually do is they give you the right to exclude others from making, selling, importing, or using your invention. And what exactly your patent is going to cover is covered in the claims, which is outlined in that red box, which are little one sentence descriptions of what your invention is. The other part of a patent is the disclosure. There are 2 parts to that. There's the description, which the start of is up on the screen, and that's going to describe your invention in words. And there are also drawings, which actually show it in drawing form. So first I'm going to talk about utility patents. They are for a new and useful process, machine, manufacture, composition of matter. They cover the way something is used or the way something works, the actual utilitarian features of an invention. They do not cover abstract ideas or natural phenomena. So I actually put a couple of mentions about court cases up there that kind of define what that is. So a natural phenomena is going to cover, as an example, a BRCA gene that someone discovered was useful in identifying whether or not someone was predisposed to breast cancer. Somebody tried to patent that once they discovered that, and they couldn't do that because everybody carries the BRCA gene. So if they did patent that, then everyone would be infringing, and that's not okay. On the other hand, if you actually genetically engineer something, like if you genetically engineer bacteria to eat oil for an oil spill, that would be covered by a patent because you've actually created something new there. Otherwise, as far as abstract ideas go, there was a huge case that was called Alice, where somebody tried to patent software that covered kind of the intermediary entity. I'm going to call it an entity, or the idea that you would have an intermediary entity for financial transactions. Well, that kind of had existed for a long time before that, and you can't just apply it to software and have it patented. So to get a utility patent, your invention has to be new and useful. So for it to be new, we say that it can't be anticipated by the prior art or by prior use. So prior art is going to be previous patents, previous applications, previous publications, or it can be something that's never been covered by a patent before. So as an example, I have a Samsung wearable device up there. My Fitbit, even if it wasn't covered by patents, would be considered prior art for that wearable. On the other hand, if somebody had been using that wearable or had it on sale before they had applied for the patent, that would also anticipate their protection. Your inventions can also have to be non-obvious, which means that if you had two inventions that were close to that wearable, like the ones on the bottom, and the examiner determines that by mixing those two wearables together, you would end up with what Samsung came up with, and that would be obvious. They wouldn't be able to get a patent on that. And your invention also has to be useful, and you have to describe in your patent exactly how to use it. So like I said earlier, your patent gives you an exclusive right to make, use, sell, or import. If someone else does that without their permission, they're infringing on your patent, and you can get damages for that in court. So when I was talking about anticipation and how things that were the same, if an allegedly infringing product fits within the scope of the claims, then that's going to be infringing on your device that's covered by the patent. There's direct infringement, which happens when one person is infringing your patent, or there's also indirect infringement. For example, if you have to make a claim that only an end user or a consumer would infringe, but the manufacturer is kind of telling them how to use it, and that's the way they're using it, and that's how they're infringing your patent, then they're indirectly infringing, and you can get damages from them instead of going after the consumer, because you don't really want to do that. As far as damages go for infringement, you can get an injunction, which basically means they have to stop selling, making, using, or importing. You can also get lost or whatever profits you may have lost from those infringing acts, or you can get what are called reasonable royalties, which is something the court would determine that you would get in royalties if you were to actually license your patent to that infringing entity. On the other side of the patent system, there are design patents. They're for new, original, and ornamental designs for what's called an article of manufacture, and they cover a way something looks. So what I have up on the top of the screen is another Samsung design patent that covers the display of a digital camera. And the bottom is what has been identified as prior art. So again, it has to be new. The standard for whether or not it's new is whether or not it's substantially similar to the prior art. And it also has to be non-obvious, which is similar to the utility design determination. And it also has to be ornamental and non-functional. So if you have a design patent or an application that you submit, and it's for something that is what they call de jure functional, which means your design is completely dictated by the way it works, then that would not be able to be covered under the design patent. It only covers the way it actually looks. Go ahead. So infringement for design patents is a little bit different than infringement for utility patents. Design patents still give you the same exclusive rights. The standard is still the same. Anticipation is substantially similar, and infringement is also substantially similar. So the huge case that's been ongoing for years now is the Samsung versus iPhone, or Samsung versus Apple. So Apple's design patent is up here, and they sued Samsung for infringement for their design patent for phones that look like this. And at the time, iPhones were the first that would ever look like that, and Samsung's, if I didn't have my case on, also looked really similar. And I believe they were found to have infringed that design patent. 400 million? Yeah. It is interesting to note that very soon after that lawsuit was filed, Samsung filed their own design patents only in the area of graphical user interfaces. They filed about 700 patents that next year. So they were like, all right, we're going to start protecting our stuff too. Direct infringement versus indirect infringement is still the same. Damages, you can still get an injunction. The only difference is that lost profits and reasonable royalties are going to be based off of the article of manufacture. If you're wondering what the article of manufacture is, it's a great question because the courts haven't even figured that out yet. For the Apple versus Samsung case, they're still trying to decide if it was just for the screen or if it was for the whole phone. So stay tuned because we'll figure it out eventually. So how do you get a patent? So a few years ago, the United States had a first to invent system, which meant if you were the first to come up with the invention, then you were entitled to protection. A few years ago, we switched to a first to file system. So there are still first to invent patents and applications out there that are still going through the process, so it's good to know that that was very recently a thing. However, now, if you and somebody else comes up with an invention close to the same time, it's going to be a race to the patent office. So whoever actually gets your application filed first is going to get the protection. So after you come up with your invention, while you're getting ready to draft your application, it's advisable to do a prior art search. They're not required, but it's easier to draft your application and know what you're up against in terms of trying to get protection if you do one. And you can look for prior art on Google. You can look for prior art from the patent office. You can look for prior art walking down the aisles of Walmart if that's depending on what kind of invention you're trying to come up with. The next step is to actually draft the patent, which you can have a patent agent do, you can have a patent attorney do, or you could, if you really wanted to, do it pro se. We already went through the anatomy of a patent earlier, so I'm not going to necessarily put you through that again. And then once you file, your application will eventually be assigned to an examiner who will go through the prior art you found, any prior art he or she found, and your application, and determine whether or not they think your invention is novel, non-obvious, and useful. And if they say it's not, then they'll give you a rejection, and you can argue with them or you can make amendments to your application. But eventually, hopefully, you'll get an allowance and pay an issue fee, and then you'll have a patent over your invention.
Hi, I'm China Smith, and I will be going over trademarks. So, trademarks defined. Trademarks can be related to goods or services. They're words, short phrases, symbols, or a combination of those things, just so that you can identify and distinguish goods or services from one producer of a good or service to another producer of a good or service. A distinctive mark or feature, particularly characteristic of or identify with a person or a thing. And so, for instance, trademarks are good for consumer identification. If you go to a grocery store and you go and get you a Pepsi, you know exactly what you're getting when you get a Pepsi. Versus if you were to go to Kroger and get a Big K Cola. You would know what you're getting versus Pepsi and Big K Cola. And you will also know that Pepsi is definitely more expensive than Big K Cola simply because of the trademark and the goodwill that Pepsi has attributed to their name. So in order to get registration for a trademark, there's 3 requirements. It must be distinctive, it has to be in use in commerce, and it also has to be non-functional. So in order to determine distinctiveness, courts will apply an Abercrombie spectrum, which will have 4 different categories, really 5, but I kind of lumped the last 2 in together. So I'm going to go into further detail with more examples past this slide, but we'll start with generic. So generic will be devices which actually name a product or a good. So for example, Apple, if an Apple company who sold apples wanted to use Apple as their trademark name, that definitely wouldn't work because people have to be able to use apples to sell other things with apples, versus if Apple, the computer, wanted to use it, is perfectly fine because it makes it not generic. A descriptive trademark merely describes the service or the goods, and in order to be distinctive, it has to obtain a secondary meaning. So an example of that could be like Freaky Fast Delivery from Jimmy John's. It doesn't say Jimmy John's in it at all, but if I said that, you would definitely know I was talking about Jimmy John's and their delivery service because they have attributed that secondary meaning to the catchphrase. Next are suggestive marks, and they just suggest a quality or characteristic of the goods. An example of that could be Best Buy. So then we have arbitrary or fanciful marks, and those bear absolutely no relationship to the products or services that they are selling. And arbitrary and fanciful marks are different. However, they are the strongest level of distinctiveness, and I'll get into that a little bit later. So generic marks, they refer to the genus of which a product is a species. So as I said earlier, it would be like an Apple company trying to sell apples and use their name as Apple. More examples of that would be escalator, aspirin, zipper, yo-yo. So pretty much you know that every diaper is not a Pamper. Every facial tissue is not a Kleenex. But it can be considered generic when consumers in their mind associate that product with a company versus associating the brand with the company. Another good example of that is Velcro. They're actually fighting that also. So you know, it's really hook and latch. It's not Velcro, but of course, no one ever says hook and latch. They call it Velcro. You know what I mean? So like that. So descriptive marks, they convey an immediate idea of the ingredients, the qualities, or the characteristics of the goods or services. However, like I said earlier, it has to obtain secondary meaning. That secondary meaning can be obtained just through in the consumer's mind. If they attribute a different meaning to the product versus what is descriptive of, then secondary meaning will be obtained. As I said earlier, the primary inquiry focuses on whether the consumer has come to identify the particular mark with the producer's goods and services. So again, like I said earlier, descriptive example would be Jimmy John's Freaky Fast Delivery. So more examples of descriptive marks. Fast bud for modems, it describes the quickness of the modem. Light for portable computers, because it describes the computer's weight. Examples of descriptive marks that have actually obtained secondary meaning, a really great example of that is sharp for televisions. Next, we have suggestive marks, and then those marks actually are going to require a little bit more imagination for you to understand what the producers are trying to sell, just based on what the name of the trademark actually is. So they are inherently descriptive. Examples of that, Microsoft, Netscape, and Silicon Graphics. You wouldn't automatically just know what these companies are selling just because of the name that's attributed to the trademark. You would have to think a little bit more to put two and two together. So our strongest type of marks are arbitrary and fanciful marks. These marks, like I said earlier, they have no relation to the actual product or service that the people are trying to sell you. Examples of arbitrary marks are different from fanciful marks because an arbitrary mark actually has it's like a real word versus a fanciful mark. That word was just made up just simply to sell that product. So example of arbitrary marks, again, Apple for computers, Sun for computers also. And then fanciful marks was like Kodak and Xerox. Those words didn't exist before these companies wanted to start selling products under that trade mark. So our next second requirement is actual use. So it needs to be in actual use in commerce. It needs to be in use in connection with the goods or the services. So if it's usually they want the trademark to be placed on the good or service. The only way that that's not required is if it just doesn't make sense for you to label the good or service. So I'm guessing an example of that could probably be these window seals. I mean, obviously the company produced and made them. However, it just doesn't make sense to brand the windows, you know? So our last requirement is non-functionality. It's very essential. If a mark is essential to the use and the purpose of the article, or it affects the cost or quality of it, you cannot get a trademark for it. So an example of that would be like this orange or outlet I have up here. You know, if you've seen these in hospitals, they basically signify to individuals that if the power was to go out, you could still plug something up to it and it would still work because it's attached to a generator. There was a case where a company tried to get a trademark on the orange outlets and they were denied that ability because it was functional and because it had a functional use for it being orange and being an outlet. Now there's also a subset of trademarks called trade dress, and it will allow the protection of the appearance of something, and a good example of that would be like the iconic Coca-Cola bottle shape. That would be protected by trade dress.
All right, my name is Evan Glass, and I'm going to be talking to you guys about copyright. I was an electrical engineer here just a few years ago, so I kind of switched over to the IU side for a few years. And also, just because I'm an electrical engineer, I kind of went into the IP side of law, thinking copyright doesn't really matter. I really just wanted to focus on patent law, so what could copyright mean? And this is why, and then until I did some digging and we learned, and copyright's still really important for everyone for quite a few reasons. First off, people don't really think about copyright whenever they do anything. So as soon as you make some form of art, like a picture, drawing, like literary work, you're gonna get a copyright. And then in order to ensure you get protection, you have to register that copyright. And just to make sure you get the most protection possible, you wanna register that your literary work or your work with the Copyright Office as soon as possible. And also, one other thing it's often overlooked, like we see this all the time with clients where they'll have a website, and on the website they'll just take random pictures off the internet and then just put it on the website and use it for commercial purposes. And then all of a sudden, you can have the person who made that artwork come along and they can sue them for infringing on their work, and all of a sudden this simple just copy and paste from Google turns into a multi-thousand, $10,000 issue litigation, and much more of a headache than you originally thought. And one other thing that's really important is code. So when you're making code is pretty tough to actually get a patent on. The patent office specifically has not allowed code itself to be patentable, and then software is also difficult to get a patent on. So how we try to get around that, they try to copyright it, and this will let inventors get some sort of protection. It may be kind of simple to get around, but at least it's something for coders. And this gets me into what exactly does it take what exactly is a copyright, and how do you get one? So there are two requirements. The first, to get a copyright, the first one is originality. You can't just say get a copyright in the phone book. But what you can do instead is get a copyright on how the phone book is organized, how the names, you can't get it on any facts, but you can just get it on how it's organized, pictures in the phone book, or say you have a map. The map itself, it's not copyrightable, but if you have like pictures within the map, or you decide which places are located, you could maybe get a copyright on that, because what the Copyright Office looks at and what the protection you get is focused on how things are expressed and how things are shown in the work. And also, it has to be creative, and this is normally a really low bar. So that goes along back to you can't just say simple things like, when I say organize, you can't just put in alphabetical order. That would not be a very simple, that's not very creative. But if you start skipping certain names, or maybe or say put names in a circle in the phone book, like that's more likely you get protection for and stop other people from doing. And then the next requirement is fixation. So in order to get a copyright, it has to be fixed in a certain medium. So an example is my words that I'm talking right now probably couldn't get a copyright for it. But if someone was recording it, then the words on that recording would be what you could get a copyright for. And what they decide for fixation, the period has to be for a transitory period. This is a really vague word that the courts are still grappling with what it means, but there have been a few cases where they decide when an information goes through like RAM in a computer, that even though it's there for maybe half a second, that actually meets the transitory period requirement. So we know at least around half a second is enough to meet that period, but like I said, my words right now would not be copyrightable. Next, these are the categories for things you could get a copyright on. A lot of things you would kind of imagine, like literary works, songs, plays, movies, and one of in architectural work, so that's probably more important to any civil engineers here, is if you do manage to have a plan, like have a drawing or plan for a building, you could get copyright registration protection for that building to make sure no one else makes a building similar to yours. And finally, you actually get copyright on compilations and derivative works. So compilation is when you take a bunch of materials together and you put them together in some form. Think of like a picture, if you've ever seen, they're especially common in puzzles where you have pictures of a show and they kind of color them specifically to make a puzzle that we have a bunch of different scenes to create a picture. So that's kind of an example of a compilation. And also a derivative work. A good example for this would be like fan fiction for a show, for a movie. That would be because it's taking off the copyrighted Harry Potter work, but you couldn't get a copyright on Harry Potter, obviously, but you could get a copyright on like your new story if you use like the different characters and any changes you make to the characters. And these are the rights you get that come along with making for getting copyright registration. The biggest ones are reproduction right and probably reproduction right's the biggest one, where you can reproduce it, but if anyone else reproduces it, then they would be infringing on your patent. And what that means, in order to infringe based on a reproduction, they actually need to take your work and copy it. If they come up with the exact same drawing by themselves, then that is not copyright infringement. And finally, this is an interesting case where a photographer literally just gave a camera to a monkey and let the monkey take pictures of itself. And the photographer tried to get a copyright protection for this, but then PETA intervened and said, no, the monkey deserved the protection. Well, the court said, no, neither of them get the protection, because in order to get protection, you have to be like a natural being, or also a corporation, as I'll talk about in a second. So this goes on to who owns the copyright. It'll be, the owner of this is the person who actually is the author. So if you draw like a painting, then you would be the owner of the copyright. And this is true unless you're doing it specifically for a company and you have like some sort of contract or agreement that says you're doing it for the company. And if that's the case, then the ownership would go straight to the company. And oftentimes this requires an agreement, and that's the best way to do it. If you own a company, you want it in writing stating that the work is being done for you. There's lots of cases where people like say like a statue and everything's done orally. So like an artist will say, I'll do a statue for like this park. Then all of a sudden the author of the statue just says, okay, this is my statue now. And the courts will have given that person the rights to the statue because there's nothing in writing that said the company that I did the statue for owned it.